Um, the pleading requirement for this, for affirmative defenses, as you all know, is that the defendants must plead an affirmative defense with enough specificity or factual particularity to give plaintiffs fair notice that the defense is being advanced. Our answer gave plaintiff counsel fair notice, or enough fair notice to where they could specifically identify them in their motion for special exceptions. And then further, under TRCP Rule 91, which deals with special exceptions, the rule states that special exceptions must point out the insufficiencies with particularity. In plaintiff's motion, they make or they claim that our defenses are ambiguous and general allegations. There is no, they do not identify with particularity what, if any, aspect of our defenses are insufficient. And then I guess just factually, this case is in its infancy. We haven't had any depositions and we're still in the process of exchanging discovery. And at this point, there isn't enough evidence. There isn't sufficient evidence to say that our affirmative defenses are, not pled with enough specificity. Thank you, Your Honor.
Response?
Sure, Your Honor. So counsel's point actually, I think makes my point, which is that they plead no facts sufficient to support any of the three affirmative defenses that they raise. Therefore, it is only an allegation and it is unsupported with anything. And although a case can be in its infancy and more discovery certainly will be helpful, there has to be some factual basis to plead one or more of these affirmative defenses, and there is none. And so that is the reason that the motion pens before the court today.
All right, let's go ahead and share screen the petition that you're concerned, or his defenses you're concerned about.
All right, Your Honor, give me just a moment and I shall pull that up.
Mary Grace, I have it pulled up. Do you want me to share my?
Sure, thank you.
Yes, ma'am.
So as the court can see, there is in paragraph 3 that Lisa McCullough failed to use a degree of care and caution that would have been used by a person with ordinary prudence under the same or similar circumstances, and that failure was a proximate or producing cause. There is no factual support for that affirmative defense. And then, Mr. Elliott, if you'll scroll down.
I think the mitigating damages one is up here. Is it in paragraph 2?
Yes. Defendant is not responsible for any expenses or damages because plaintiff failed to exercise reasonable care in mitigating damages. Again, there's no supporting data for that statement. It's a mere allegation. And then the third one is in paragraph 4, mentioning third-party defendants, counter defendants, and other responsible third parties, but not only not naming them, but not giving any factual basis for why defendants so believe that third parties would bear any responsibility.
All right, I'm going to go ahead and grant the special exceptions. You need to provide some specificity here. I know it's a notice pleading state, but we'll give you 7 days to replead. So have you submitted an order on this?
Yes, Your Honor.
Let me take a look.
It was filed contemporaneously with the special exceptions.
Okay. I have the order now. All right, you have 7 days to replead. And I'm signing the order right now and sending it to the clerks.
Thank you, Judge. Thank you,
Thank you,
Mr. Cody.
Judge.
You guys have a great rest of your day, okay? And wait, let me
Yeah,
just check
you
something
too.
on your case. Is your case set for trial?
I don't believe we have a docket control order yet. We need to circulate
Well,
dates.
let me look at this real quick.
Sure, thank you.
Hmm. Was this a level 2 or level 3 case?
I believe it is pled as a level 2.
I'm showing it a level 3 in discovery.
Okay.
Judge.
I stand corrected.
All right, when do y'all want to set this for trial?
Does the court have availability in March of 2026?
Sure, that works.
That works for us as well.
Gonna do March 3rd,
Yes, sir.
counsel?
Yes,
Yes.
sir. Yes, Judge.
And then who do you want to use as a mediator?
We could circulate some names at the top of,
Let's pick a mediator.
okay,
I've used Jay Zaleski in the past, and he's out of the Dallas area. Mary Grace, if you're agreeable.
that's fine.
Yeah, he's on our list. Jay Zaleski, Rhonda.
Got it.
Okay, so we've set this for trial on May 3rd, 2025, and we have appointed Jay Zaleski. Anything else today?
No, Your Honor.
All right, you guys have a great rest of your day, okay?
Thank you, sir.
Thank you.
All right, next thing we have is a motion to dismiss. Are both sides here on Aguilar versus Freedom Forever, Texas?
Plaintiffs here, Your Honor.
Good morning, Your Honor. Kelsey Imam on behalf of Freedom Forever.
All right, Tony, let's go on the record on DC 2422255, Aguilar versus Freedom Forever, Texas, LLC. Counsel, make your appearances.
Good morning, Your Honor. Chris Arnell here for the plaintiff, Mr. Aguilar.
Good morning, Your Honor. Kelsey Imam on behalf of Defendant Freedom Forever.
All righty, let's go ahead and start.
Yes, Your Honor. We're here this morning on Freedom Forever's motion to dismiss filed under Rule 91A. What the court has before it, though, to consider is only Freedom Forever's motion to dismiss because the plaintiff neither timely responded in opposition to the motion nor timely amended his petition in response to the motion. If I may share my screen, Your Honor.
Sure.
Are you able to see this brief PowerPoint?
Yes.
So Rule 91A requires that a plaintiff respond to a motion to dismiss under Rule 91A at least 7 days before the hearing. The 7 days before this morning's hearing was last Monday, and plaintiff did not file his response until last Friday. More pressing, though, is the rule that I've got on the screen, Rule 91A5, that requires a plaintiff to amend his petition in response to a Rule 91A motion to dismiss at least 3 days before the hearing. Failure to do so means that this court must not consider the amendment when ruling on the motion to dismiss. Rule 4 of the Texas Rules of Civil Procedure provides that when a time period is described as 5 days or less, as the 3-day requirement in Rule 91A that I just showed you, Saturdays, Sundays, and legal holidays are not counted for the purpose of the the time period. So what the court is confronted with is an amended petition that was filed only one day, the Friday before today's hearing, before the hearing on the motion to dismiss. And so the court should not consider plaintiff's amended petition filed on Friday or their belated response filed on Friday when considering Freedom Forever's motion to dismiss. Instead, looking at the motion to dismiss on its face, the court should grant the motion because all of the claims asserted in plaintiff's petition are time barred. They're barred by their applicable statutes of limitations of both 4 and 2 years. So in this case, the plaintiff has advanced a claim for fraud and 2 claims under the Texas DTPA, the Deceptive Trade Practices Act, as well as a claim for declaratory relief. Fraud carries a 4-year statute of limitations. The DTPA has a 2-year statute of limitations, and a claim for dec relief, that statute of limitations follows the other claims that it accompanies. So in this case, fraud, 4 years, or DTPA, 2 years. In plaintiff's petition, he alleges that in August of 2020, he was approached by someone from Freedom Forever who sold him on a residential solar panel system. He alleges that the installation of that system was completed in November of 2020. He doesn't specify what day in November of 2020, but even giving plaintiff every benefit of the doubt on the face of his pleadings, he says November 2020, we'll give him November 30th, 2020. He had from that day 4 years to file a claim for fraud and 2 years to file claims under the DTPA. And that's because all of the alleged misconduct that the plaintiff complains of in his petition is conduct that necessarily happened before this contract was entered into or before the solar panel system at least was installed. Plaintiff alleges that promises were made to him about what the solar panel system would do in terms of saving him money or generating a tax refund, and that those promises did not bear true, and that he knew that as early as November 2020. So the promises that he's complaining of would have necessarily occurred before November 2020. That's when the statute of limitations, the time period begins to accrue. For fraud, at the time the fraudulent statement is made. For the DTPA, when the deceptive act occurs. So that means plaintiff had until November of 2022 to file a claim under the DTPA, or until November of 2024 to file a claim for fraud. Instead, plaintiff waited until December 23rd, 2024 to file his claims. They're plainly time barred. They're past the 2-year, well past the 2-year statute of limitations for the DTPA, and at least 3 weeks past the statute of limitations for fraud. Now, I don't think that the court should consider plaintiff's response or amended petition for the reasons I talked about at the outset of my argument. But even if the court is inclined to consider the amended petition or the response, they don't do anything to change the outcome on the motion to dismiss. All that plaintiff has done in his amended petition is add a sentence that in January of 2024, the plaintiff stopped talking to Freedom Forever about his concerns. And then he adds a paragraph at the end attempting to invoke the discovery rule. The January 2024 date, first of all, it's not stated with any greater specificity than January 2024. It appears that plaintiff has picked a time period out of thin air that would render his petition timely. And more importantly, though, he doesn't allege any facts about what was happening in January 2024 that would make that the time when his claim for fraud or his claims under the DTPA accrued. He doesn't allege any facts to assert why it was at that time that he started to believe that he had been defrauded, or why he couldn't have known prior to that time that he had been allegedly defrauded or that Freedom Forever had engaged in a deceptive trade practice. On the contrary, the rest of his petition negates that assertion because, as with his original petition, he asserts that Freedom Forever approached him in August of 2020, made promises about what the solar panel system was going to do, and that in November of 2020, even in his amended petition, he pleads this, that he realized that those promises were not going to come true. It seems that plaintiff wants to pick his accrual date based on when he decided, by his allegation, to stop discussing his concerns with Freedom Forever. But that's not how the accrual date for any of these statutes of limitation works. even if the court's inclined to give credence to the discovery rule, that still requires that the court look at when the plaintiff knew or should have known of a fraudulent conduct or deceptive trade practice. There's been no allegation of fraudulent concealment on the part of Freedom Forever. And looking at plaintiff's petition, even the amended petition as a whole, it's clear that plaintiff knew or should have known in November of 2020 by his own admission that he was concerned that the promises Freedom Forever had made to him were not going to come to fruition. That's when his claims, the statute of limitation on his claims accrued. And when he filed his petition in December of 2024, he simply filed too late. This is as clear cut as it gets under Rule 91A, that plaintiff's claims have no basis in law because they're barred by an applicable affirmative defense, the affirmative defense of statute of limitations. And so we would ask that you grant Freedom Forever's motion to dismiss and award Freedom Forever its fees for having to file the motion on the statute of limitations basis.
Okay, great. Response? And first off,
Yes.
what was the response untimely?
Your Honor, admittedly, yes, the response was untimely, and it's because it took quite a bit of time to get with my client to uncover the facts as to when he realized, finally, after the back and forth with the solar panel company, when he was defrauded. And Your Honor, just taking a step back and talking about the nature of these kinds of cases, it's important to understand a couple of key things. One of them is the main promise that they're getting these people to sign up into these solar panel contract deals, and that is, we're going to have a $0 electric bill. We're going to eliminate it. We're going to make that go away. And Your Honor, something that was in our original and amended petition is this promise that if we don't get you that $0 bill, we're going to send someone out there. They're going to inspect the system. We're going to add solar panels if we need to, or we're going to repair solar panels if we need to. And so, Your Honor, we didn't know that he was defrauded in November of 2020. That's simply when my client said the panels were installed and they began a discussion of how do we resolve these issues. And that's the key when you're looking at accrual in the context of fraud in the DTPA is with due diligence, when did the plaintiff know or should have known that there was some sort of fraud or deceit involved? And when you promise your customer that, hey, we're going to work with you, and it might take a year or two for you to realize these benefits you were promised, then the customer is not aware that they've been defrauded. They simply think they're working together with the company to get what they were promised. And that's what happened with Mr. Aguilar. Your Honor, admittedly, it did take us a while to get these facts in the amended petition as to the exact date that he called Freedom Forever, and that was the last time they spoke, and that's when he realized that he was not going to get the benefits he was promised. But even if Your Honor wants to just look at the original petition, I'm fine with doing that because under Rule 91A, what the court's required to do is take a look at the factual allegations, take them as true, and whatever reasonable inferences can be drawn from those factual allegations to support the fact that Mr. Aguilar was not aware that he had been defrauded. And if you look at our original petition, Your Honor, it's in there. We talk about how for months they have a back and forth with Freedom Forever on figuring out these solar panel issues. They tell Mr. Aguilar, hey, it's going to take at least a year for the energy to cycle. And Your Honor, with that, just that factual basis alone in the original petition and the reasonable inferences you can draw from that, we're well within the 4-year statute of limitations for common law fraud. And Your Honor, I would argue we're still within the 2-year statute of limitations for the DTPA because, Your Honor, these people don't know they've been defrauded. It takes time. And these solar panel companies are taking advantage of stringing people along saying, just work with us for a year or two until finally they ghost their customers. That's what's happened in Mr. Aguilar's case, Your Honor. And that's why we're here today, Your Honor, trying to make sure that the court's well aware of the factual basis for when these claims accrued and to show, Your Honor, that Mr. Aguilar wasn't just sitting on his hands. He was, to the best of his ability, trying to exercise due diligence with the defendant and figuring out, am I ever going to get these things I was promised? And Your Honor, it wasn't until January of last year that he finally realized he wasn't. And for the court's reference and for defense counsel's reference, we're working on obtaining the cell phone records that will give us an exact date. And we intend to supplement that once we uncover that, Your Honor.
Can you share screen in your original petition where you assert the discovery rule?
Your Honor, it's not in our original petition, but the factual basis supporting it is in paragraph 11.
Okay,
Would Your Honor like me to share screen that?
sure.
Can Your Honor see what I've got here in front of me?
Yeah. That's not very detailed. It doesn't give any idea of like dates or anything like that.
May I respond briefly, Your Honor?
Yeah.
So the statute of limitations accrues at the for fraud accrues at the time the fraudulent statement is made. For DTPA, it accrues at the time the deceptive act happens. That would be, in this case, taking plaintiff's allegations as true when Freedom Forever made a fraudulent representation about his energy savings, or when Freedom deceived him into thinking he was going to get some benefit that he didn't get. That's when the statute of limitations accrues. It's not when the fraud is realized. It's not when he's gone back and forth and then decides, okay, now I believe I have been defrauded conveniently at a time that would make my petition timely. It's when the misconduct occurs. In this case, the misconduct had to have occurred before the solar panels were installed in November of 2020. Even in paragraph 10 on plaintiff's screen, in or around November 2020, after the solar panels were installed, plaintiff noticed that the panels did not generate electricity at the levels promised by defendants. The plaintiff knew enough, even at that point, according to plaintiffs, to start talking to Freedom Forever, to ask about the panels, to call into question the veracity of the representations, that had been made to him from his perspective. That's when the statute of limitations accrues. And this isn't something where the statute of limitations requires that you file within 30 days, right? He had 4 years to file a claim for fraud. He had 2 years to file a claim under the DTPA from the date these assertions were allegedly made that were allegedly fraudulent. And so this is plaintiff coming back too late, too little, too late, trying to backdate and kind of take control of when the statute of limitations accrues, and that's just not what the law says. It accrues at the time the alleged misconduct occurs.
But if he inserted the discovery rule properly, the limitation period does not begin to run until the fraud is discovered or could have been discovered the exercise of reasonable diligence. I mean, there is a discovery rule for fraud.
Yes, Your Honor, but even in his original petition, by exercise of reasonable diligence, he says he knew. He says he knew in November of 2020.
Your Honor, may I be heard on that?
Sure.
Your Honor, that's not what we're saying. If you just read the petition, we're saying in November of 2020 is when he noticed the panels aren't generating levels that were promised by the defendants. And if you read right below that, we talk about how for several months he's going back and forth with the defendants and how they tell him you're going to have to wait at least a year for these panels to cycle the energy, which is something I've heard in dozens of cases, Your Honor. This is exactly how these solar panel companies operate. And Your Honor, if you're looking for some sort of temporal designation as to when these claims could have accrued just based on the original petition, we know at the very least it would have started sometime early 2022 because they talked for several months with these solar panel representatives. Then after that point, they told them, you're going to need to wait a year. And Your Honor, it wasn't until I had a chance to talk to my client and we went back and forth to discover, okay, when's the last time you actually talked with the solar panel representatives to try and solve your issues? And that's when we learned it was in January of last year. As I mentioned, Your Honor, we're working to get the cell phone records to get an exact date. But if you're just looking at the face of the original petition, Your Honor, we're still well within the 4-year statute of limitations for common law fraud.
All right, I'm going to go ahead and grant the motion to dismiss as the DTPA. I'm going to deny it as the fraud. Can you give me an order on that, Miss? How do you see your name? Imam.
Iman. Yes, Your Honor, I will.
And make sure it says at the beginning that this was heard on April 14th, 2025 over Zoom on the record with all parties present, and share a copy of that with Mr. Arnell and get that to me by tomorrow morning. Okay.
I will. Thank you, Your Honor.
Thank you, guys. You have a great rest of your day.
Your Honor, may we be excused?
You may.
All right, thank you.